Welcome, everybody. Thank you for continuing to be here throughout the day. I realize it's Friday afternoon, but we have a really exceptional panel for our last panel of the day before our keynote address. I'm Steve Miley. I'm the director of the Immigration and Human Rights Clinic at the Binger Center, where law students represent asylum seekers and trafficking victims. And asylum is the subject of this panel, entitled The Attack on Asylum at the Border and in the Law. And as Erica Lee mentioned in the first session today, it is an unprecedented attack. Typically, or in the majority, as a matter of administrative policy and U.S. Attorney General opinions. And an attack really on three fronts, or at least three fronts. First, as to access to the asylum system itself. Secondly, limitations on the criteria through which an asylum applicant can be granted asylum. And third, increasing pressure on judges who make these decisions. A few of the policies or examples of this attack include the zero tolerance policy. That was the policy that resulted in the separation of children and parents. The turnback policy, which was an amalgam of restrictions on asylum, perhaps most notably requiring asylum seekers to apply for asylum at designated ports of entry. Third, the Remain in Mexico program, euphemistically called the Migrant Protection Protocols, although it's unclear which migrants are protected by those protocols. And finally, the Safe Third Country policy, which boils down to requiring those who traveled through any of the northern triangle countries of Central America on their way to the United States to go back to those countries and apply for asylum. The U.S. is currently in the process of negotiating or has already negotiated safe third-party agreements with all three of those countries. If that policy continues, it effectively means that the only folks who can apply for asylum or will be allowed to apply for asylum in the United States are asylum seekers from Mexico. At least those who travel by land through Mexico in order to get to the United States. We also have two examples of those Attorney General opinions, matter of AG and matter of LEA. And so in order to discuss some of these policies and decisions that have restricted asylum, we've got an excellent panel who have defended immigrants in a variety of venues, both on the ground and in the courtroom. I'm going to introduce them in the order in which they're going to appear today. First, we have Daisy Ocampo, who is a staff attorney at the UC Davis Immigration Law Clinic. She's going to be talking about conditions of confinement for immigrant children. Then we'll have Jody Goodwin. Jody's going to talk about, Jody practices immigration law on the border in Harlingen, Texas. She's going to be talking about due process and the humanitarian crisis of the Remain in Mexico program. Zach Albin, who is a U of M graduate, also took my immigration law class, nice job. As did all three panelists, with the exception of Kathy, in the previous panel. So nothing, warms the heart of a professor more than seeing a former student doing the kind of work these guys are doing. So it's wonderful. Zach is the Albert Sachs Clinical Teaching and Advocacy Fellow at Harvard. He's going to be talking about particular social groups and the Board of Immigration Appeals, especially those two cases I mentioned earlier, AB and LEA. And then finally, Allison Griffith, who is a staff attorney at the Advocates for Human Rights, an NGO here in Minneapolis that does tremendous work on behalf of refugees and asylum seekers. Allison's going to be talking about the limits on discretion of immigration judges. Because the attack on asylum is so broad, we have 4 panelists rather than 3, which means we're restricting everybody to 15 minutes because we want to leave plenty of time for Q&A. So Daisy, you're up.
All right, so Steve just mentioned a lot of different attacks on asylum. I will be talking about none of those. I'm talking about a specific attack on asylum in a different context that most people don't really hear about as it relates to asylum. I'll be talking about detention of children under the Flores settlement agreement. So to go into that, I'll talk about a little bit background about what the Flores settlement agreement is, how it's recently been under attack by this administration, how detention functions as a deterrent to seeking immigration relief, which relates to asylum. So I promise I will connect with the other presenters today, and how we fight back.
I don't think it's working. Oh, there it
It's
is.
delayed. Oh, there we go. All right, so dismantling the Flores settlement agreement is a key goal of this administration. And we know this because it's been stated numerous times, including in a letter to Congress, January 4th of this year, where President Trump listed terminate the Flores settlement agreement as the most pressing legal change desired by his administration. Right? So what is Flores, and why does the government want to get rid of it? The Flores settlement agreement was created in 1997 when the government agreed to settle ongoing litigation about conditions of detention for detained immigrant children. And yes, 1997 is correct. It's not a typo. It's been in place for 22 years. The Flores settlement agreement is an agreement with the U.S. government that has the force of law, and it sets the minimum standards of conditions and care for children held in immigration detention in the U.S. There's been a lot of litigation around the Flores settlement agreement in the past 4 years, and some of that litigation has clarified that the settlement applies both to unaccompanied and accompanied minors. So this is just a small overview of what the settlement requires. It requires detained children be treated with dignity, respect, and special concern for their particular vulnerability. It implements a policy of favoring release of children to parents and other sponsors as opposed to keeping them in detention. It requires detained children be placed in the least restrictive setting appropriate, which this is like a key term of art that has been litigated and is still being litigated. It requires children to be placed in facilities licensed to care for dependent minors. So again, this kind of goes back to the special concerns for their particular vulnerability. It requires licensed programs comply with state child welfare laws and regulations, meaning it's states that create these licensing programs that kind of provide a roadmap as to how these children should be treated in detention. It's not the federal government providing these guidelines. It designates when a child can be placed in a higher secure facility. So there are different levels of facilities. There's shelters, there's residential treatment centers, there's staff secure and secure facilities. There's also short-term and long-term foster care. They all have different restrictions on children's ability to leave the facility as they please, and each level restricts them a little bit more. And it requires a reasonable right to privacy for detained children, meaning they should be able to see their potential sponsors in a private setting, talk to lawyers privately, have phone calls, have mail correspondence that isn't being seen by those holding them in detention. Okay. So the recent attacks on the Flores settlement agreement, some of you may have heard of a recent decision. It was end of last month, so barely a month ago. It resulted from last year's notice of proposed regulations related to the Flores settlement agreement. When the notice of proposed regulations was issued, there was a comment period. Right before that comment period ended, the Flores Council, including UC Davis, filed a motion to enforce the settlement agreement, highlighting the deficiencies of the proposed regulations. The court felt it was premature to address those just then, so they held off until the actual regulations were published, which happened August of this year. As soon as they were published, both parties had to address the new regulations to see whether there was still a disagreement as to whether they were consistent with the Flores settlement agreement. And we found many inconsistencies. There was a hearing on September 27th at the U.S. District Court, Central District of California, where Judge G upheld the Flores settlement agreement and blocked the government from implementing its new regulations, which to us, this was a huge victory because the Flores settlement agreement, again, protects children. It has, like I said, the state licensing requirements, which the federal government was trying to essentially do away with. It also sets limitations and, again, that policy of releasing children, the favor of releasing children, whereas the regulations actually proposed indefinite detention. Due to time constraints, I won't go too much into breaking down what the court said about all the inconsistencies, but again, some of the inconsistencies were about the length of detention for children, like I said, indefinite detention as opposed to favoring release to sponsors and family members. The other issue was the definition with licensing facilities. The court ruled that the section of the regulations were patently inconsistent with a substantive term of the agreement because the purpose of the licensing provision is to provide class members the essential protections of regular and comprehensive oversight by independent child welfare agencies. So as I mentioned, the Flores settlement agreement put in place that there was state licensing requirements and state child welfare decisions that were at play, whereas the regulations were proposing that if these state licensings didn't exist, they could create these facilities where federal licensing would be provided and there would be no external oversight. And as I mentioned, they would have permitted detention of minors in secure facilities on many grounds. The Flores settlement agreement actually lays out what it takes to what's called step up a minor to a more secure facility. And under the regulations, they were allowing for secure placement, such as like in juvenile detention centers, just based solely on ambiguous danger to self or others. So why does the Flores settlement agreement matter? Like, why are we fighting so hard to keep it as it is for now? And it's because it provides external oversight, right? It allows Flores Council to go in and do site visits at these facilities, whether they're ORR facilities or they're CBP facilities. And actually, Jody can speak to her experience this summer helping out with monitoring the facilities in Texas this summer that led to a temporary restraining order based on children who were dying, who were not having any access to showers, lack of sufficient food, overcrowding. There were, I think it was 60 plus declarations of just these atrocious conditions where even babies who were soiling themselves were not given clean clothes, were not allowed to bathe for days, almost months. And so again, this is why we need Flores to stay where it is to protect these children. Let's see. So as promised, I'm getting to the part where Flores relates to the asylum panel today, which is how does detention of these children function as a deterrent to seeking the relief such as asylum? Right? And it relates to why the least restrictive placement matters and why release matters as well. So these programs designed to release them to family or sponsors. Let's see. So before we get into the how it deters minors seeking release, it's important to know the numbers out there. So in the last few years, the population of children in custody has increased significantly, even though the number of children arriving at the U.S. border hasn't, right? And so what's going on here? So these two tables are set to explain that distinction, right? So The percentage of minors detained at the outcome of their immigration proceedings. In 2016, it was 3.04%. In 2019, it's 30.56%, right? So it's increased significantly in the last few years, which is concerning. We have a lot more children being detained in immigration custody. And I promise I don't suck at math. If you look at these numbers, at first it's like 2019, you have 30.56% of children detained at the time of the outcome versus 48.90% of children who were never detained at the time of the outcome of their case. The separate 20.53% are children who were detained when their case began, but were subsequently released before the outcome of their case. So that's where the numbers kind of go. I thought the best way to kind of bring perspective to this was to show an example of a case that we've seen. Again, this is a fake name, but Ricky was a 15-year-old boy from Honduras. He was fleeing gang violence. His brother had already been killed. When he arrived, he was in Custom and Border Patrol detention for a few days and then transferred to ORR custody. At first, he was thinking, I'll be released any day now, and unfortunately that was not the case. After 5 months of detention, he just lost his will to keep fighting his case, even though he had potential claims to asylum and a potentially very viable T visa claim. So he ultimately accepted voluntary departure just so that he could get out of detention. Ricky is not the only case like this. These two tables show, again, the same control groups detained minors at the time of the outcome of their case versus minors who were never detained during their immigration proceedings. Again, never detained just means that their immigration case started after they had already been released. And as you can see, in 2019, the percentage of detained minors who accepted voluntary departure were 11.86% versus the children who were never detained, which was less than 0.5%, right? And what these numbers tell us, for example, in 2019, minors detained in ORR custody were 25 times more likely than never detained children to accept voluntary departure. So this is why the number of children in custody and the coercive nature of custody matters. And I break this down just so that you can see the comparison of how this has worsened. In 2017, minors detained in ORR custody were 13.6 times more likely. In 2018, it was 14 times more likely to accept voluntary departure, and now we're at 25 times more likely. Okay. There's other factors resulting in prolonged detention. There's fewer sponsors coming forward, leaving children in ORR detention for longer. There's enhanced immigration enforcement, such as ORR sharing sponsor information, fingerprints, which is causing parents and other potential sponsors deciding not to come forward or to stop the process for sponsorship. So these are all things we're trying to address. Part of that is through our current litigation in Lucas R. v. Azar, where we brought claims related to Flores, and a lot of people have a really hard time distinguishing between Flores and Lucas R. Lucas R. is essentially the due process claims about when there's a denial for sponsorship. What is that process for challenging that denial? When there's a decision to step up a child to a secure facility, what is that process for challenging that decision, and so on. And so that information's the 5 claims are provided in these slides. All right. Here you go.
Okay, so we're just going to roll on through, and I feel like we're going to hit different topics as we go along. And I'm sure that there's probably questions that brew in your mind. If you don't mind, we'll wait till the questions for at the end. So I'm dyslexic, And I'm also a very visual learner. So my part of this program is just going to be filled with a lot of pictures. So I'm sure you're happy about that. Although I think online you'll find a fuller presentation about the Migrant Protection Protocol, Remain in Mexico program that actually has some more typey law stuff. So we'll just look at the pictures for now. So my name is Jody Goodwin, and I practice down on the border, and I've been practicing there for 25 years. So I've been through sort of every different version of crisis that you can imagine along the border. And what I can tell you about the current issues and crisis that is happening on the border, that started roughly around May of 2018 with the implementation of zero tolerance, is probably the hardest legal work I've ever done in 25 years. So this last year and a few months that has gone by has been pretty rough, and what it's resulted in is me practicing law and doing trials in a double-wide trailer. And I don't say that in any kind of joking matter, because this first slide, which is not the first slide on my presentation. Hold on. Let's try it again. You didn't get the mega short version of the... All right, well, we'll figure it out. Well, you didn't get to see the double wide, sorry. I'm going to go back because that's not the same order that I have them on mine. We'll look at the chart anyway. So I wanted to be able to show you a picture of the tent courts because you may have heard about the fact that the Trump administration has opened up 2 tent court facilities along the border. Basically, they're court facilities that have been erected in the parking lot of the CBP ports of entry, both in Laredo and in Brownsville, Texas. And they look like a MASH unit, like a mobile army hospital, basically. They're a series of carp-type tents, like wedding tents, those big rectangle things. And those are used as waiting rooms, the rectangle tents. And then they have pod storage facilities, you know, the kind that they drop off in your driveway when you're going to move, and you fill them up, and then a truck comes and picks them up. That is your room that you can actually meet with your client in. So I've gone from practicing law in real buildings to meeting my clients either on the streets in Mexico or in a pod building structure, and then going to court in a real double-wide trailer. It's actually a double-wide that has a giant screen attached to one of the walls, and then there's usually about 50 chairs for people to come in to court for the tents. And I'm really sorry you didn't get to see that picture. So the reason why they've started this tent court process in both Laredo and in Harlingen is to make it so that individuals who are forced to remain in Mexico come back to their court hearings, but they don't have to be transported to an actual court building like they do in San Diego or El Paso, where people will come to the port of entry for their court hearing, and then ICE will transport them from the port of entry to the actual court center. So there was $155 million appropriated to be able to pay for these MASH unit courts that are built up. And the reason why that they've done this, and we've got to sort of keep in mind and keep in the back of our heads, what's sort of gone on in terms of why are we trying to sort of go after MPP now? And you have to look back at statistics. So there's 3 slides that I'm going to show you with charts that basically go through and give you a graphic look at what did apprehension rates look like along the southern border. And what I really want you to focus on is that orange line. That orange line is fiscal year 18. So that's the first fiscal year within the Trump administration. So there was, pretty steady and almost identical rates of apprehensions. It varied somewhere around the 20,000 up or down range, but it's fairly steady. But then we had that happen. So the next fiscal year 2019, saw a steady rise beginning in January of 2019 to the spike in May of 2019 in terms of the number of apprehensions. But we got to keep that in context, though, because there's a lot of rhetoric that would indicate that the border is being overrun, or that there's a large number of apprehensions, more than ever before, huge numbers of people. Not true. So let's look at this slide. This one has a picture on top of what you really need to see. All right, let's try again. That's the one I want you to see. So this slide tells the real story, okay? So don't buy into there's more people coming to the U.S., we're being invaded, overrun. This is a 20-year time frame, okay? If we look at a 20-year time frame, aside from that little spike in May of 2019, we're roughly averaging around 50,000 apprehensions or less per month. Now, you go back and you look at the early 2000s, where we were seeing over 200,000 apprehensions per month. So the rhetoric that there's some sort of invasion, or that we've got high numbers of people coming across the U.S. border, it just doesn't pan out in terms of the government's own statistics. So why do we do this, and how do we get to MPP at this point? Because for the first time, what we've come up with is, and I'll go back to that other slide so you can see the picture, because this is really the reason. For the first time, we've seen a concerted effort on the part of migrants themselves to take matters into their own hands with respect to their safety in being able to migrate. So that's where we saw the rise of the use of caravans, 2018, 2019. And instead of having people subjected to smugglers and coyotes and being trafficked along the way, a large number of individuals decided that the only way that they were going to be able to safely migrate from the northern triangle of Central America to the U.S. is if they did so in numbers. There's power in numbers, there's safety in numbers. And because they started traveling as a group, that's where we got the rhetoric of being overrun and invaded, et cetera. Numbers don't prove it out. It just meant that these people were not relying upon underground, illegal smuggling routes. They were relying upon themselves and the safety of the numbers. So that's how we get MPP now. So if we keep going on, you can look and see that throughout MPP, which was implemented initially in January of 2019 in San Diego, you see that there's a cumulative return. The slide is a little bit old because we just had the closeout of the data for September of 2019 as well. And currently there's over 53,000 people who have been sent back to Mexico under the MPP program. The data that was available when this slide was done showed 42,000. Another month along, we have another 11,000 people that have been added to those numbers. But you can see that there's sort of just a stair step of cumulative effect of where people have, the numbers of where people have been sent back to Mexico. Now, it's interesting because it's concentrated in 4 distinct areas where people get sent back. El Paso, Laredo, and Matamoros, Brownsville, Matamoros in Texas, and then San Diego, Tijuana in California. They've also opened up Mexicali, but there's no court in Mexicali. People that get sent back to Mexicali have to go to court in Tijuana, San Diego. And they've also opened up the Eagle Pass MPP location with no court. People who get sent back through Eagle Pass have to come back around and go to court in Laredo. So you have those 5 areas. So what happens? People who are subjected to MPP, The conditions in each city are different, and I'll show you some pictures from different cities so that you can maybe get an understanding. I'm most familiar, obviously, with the Matamoros area, simply because I helped start a pro se clinic in Matamoros, and I had been crossing to Matamoros with a Team Brownsville, a humanitarian aid organization, for over a year, just to provide legal orientation to people who were waiting to come in and ask for asylum. In Matamoros, we have a refugee camp. There's no other way to describe it. It is this same style of refugee camp that has developed in places like Rwanda, in places like Bangladesh, places like Jordan. The same sort of style in terms of tent camps. When those individuals that are living in the tent camps have to go back to court, they have to line up really early in the morning, like 4 o'clock in the morning, and they have to wait to be able to be let in 10 people at a time at the bridge. Once they get inside the tent facility, they're waiting around probably for about 4 hours before their court will actually start. They don't have food, and they have water. They have started to give them water during that time. And then once they're done with their court hearing, then they're sent right back through the bridge back to Mexico. So it's very difficult, especially because in the Matamoros court and the Laredo court, both of the port courts, they are attached to cities that have the same threat level security warning as Syria. So Tamaulipas, Mexico, is one of the most dangerous Mexican states. And if you are in MPP, either in the Brownsville court location or Laredo, you're living in a war zone on the other side of the border. So that's a little picture of the tent camps. This picture was taken about a month ago when the unofficial census of the refugee camp in Matamoros stood at about 800 people. The unofficial census, because there is no way to take an official census, is about 2,100 men, women, and children at the tent camp as we speak. 120 people a day get sent back, so it's a growing population. This is how they bathe. They bathe in the river. There's no clean water source available at the refugee camp, so everyone bathes and washes their clothes in the river. And there's a makeshift memorial to the men, women, and children who've drowned in the river, either trying to cross or bathe. This is another picture of, this is different areas. Casa del Migrante is actually located in Laredo. It's a small shelter. It's always full. There are shelters in Matamoros as well, but they're always full. The capacity is only about 300 people total to be in a shelter. And there's been about 13,000 people sent back to Matamoros City, just that city alone. And the other tent facility is a picture of a tent facility in Tijuana. Attorney representation. So this is my plug for all you guys from this cold land to come visit the border where we don't really have winter. So if you'd like an escape to some warmer weather, we would love to have more attorneys to come to visit, either on a short-term basis or on a longer-term basis, to either do intakes or to help with merits. Attorney representation is dismal. In the entire MPP program, you can see the statistics as compared to regular non-MPP cases. I can tell you that 300 people a day are processed in court. The max I've seen is 3 attorneys in court, and that was on one day. Most of the time, it's usually just me, and some days there's one other attorney that shows up. So if you'd like to come and show up, that would be awesome. It's taxing on everybody. It's taxing on the attorneys, it's taxing on the judges. In addition to doing the MPP dockets, we have 10 judges in the Harlingen district that also have to do something with their regular dockets. So our regular dockets are now pushed out 2 to 3 years into the future. They're under a lot of pressure as well to be able to complete as many cases as possible for the case completion goals. And they're not very sensitive in terms of the conditions that the migrants are forced to live in Mexico while they wait. So for example, the trial attorney can come to court without a file and not be ready, But if the migrant who's homeless and lives in a tent and doesn't have access to a lawyer or a translator, doesn't bring all their evidence translated to court, they get scolded. So I think tempers are, high, morale's pretty low, just because of the numbers. There's lots of due process concerns. We could probably talk a lot about that. The one that's most concerning to me is the fact that the proceedings are not fully translated to individuals. So individuals come in and out, even those that have spent a significant amount of time in our pro se clinic, they come in and out and they don't really know what happened in court. They have no idea of how things came out in court. So that's a big problem. This last slide basically talks about other limitations on the judge's ability to be able to affect due process within their courts because of the limitations that have been put on them through politics, through decisions from the Attorney General. And then finally, actually, that one was taken out. I'm sorry, y'all aren't getting the version that we took out a bunch of the righty stuff. Anyways, well, we'll go with that. So finally, I just wanted to offer that there's actually a solution, and the solution is to end MPP, and we can certainly go back to the way that we used to do cases where individuals could go to family sponsors and prepare and present themselves for court. And if you want to talk to me about MPP later, I'll be around for only one more day in this cold weather. Thank you.
Thank you, Jody. First, I'd just like to say it's very exciting and meaningful for me to be here, to be presenting on this topic. I got my start working in asylum law from Mark Fry, a local attorney who's here today, and then had the opportunity to challenge some of the really problematic standards I'll be talking to you about today as a student in the Center for New Americans Federal Immigration Litigation Clinic. So the topic of my part of today's presentation on the panoply of horrors we're dealing with is the evolution of particular social group law. And particular social group, or I should say membership in a particular social group, is not part of every asylum case, for reasons I'll get to in a minute, but it is a critical component of many of the asylum cases that are being put on by immigrants coming from Central America, and just as a more broad proposition, immigrants who are facing domestic violence or gang-related violence back home. And as I alluded to, what we've seen in really the past over a decade, but particularly under this administration, is the executive branch using the regulatory authority to interpret the law that's ostensibly been committed to the Attorney General to interpret particular social group out of the law, take it away as a basis for seeking asylum, and therefore kind of transmute it into a cudgel for denying claims irrespective of the underlying merits. So what am I talking about when I use this weird term, particular social group? The language, as you can see, comes out of originally the 1951 Refugee Convention. Asylum law at its core is refugee law. The Refugee Convention was developed by the international community in the wake of the Holocaust, in the wake of other horrors, where the international community came together and said, unfortunately, this is a pattern. We're seeing people being persecuted for reasons that are central to their identity, and we don't have a system in place for dealing with it, for offering people protection who fall within those classes when the state fails to. So the reasons that are set out in the Refugee Convention, as you can see, are race, religion, nationality, political opinion, and membership of a particular social group. That law is incorporated directly into American jurisprudence via the 1980 Refugee Act. The connection's really important. In the Cardozo-Fonseca decision, the Supreme Court actually noted the purpose of the Refugee Act was to bring the United States into conformity with this international refugee convention standard. So you might think we should look to the drafting materials that go along with the Refugee Convention to figure out what particular social group means. Unfortunately, there's not a lot of guidance there. There's just not a lot of commentary from the different state actors in the negotiations or in the proceeds adopting the Refugee Convention as to what this term meant. To the limited extent there is kind of consensus about it, the idea is particular social group was added to be forward-looking, right? Those other grounds I mentioned, race, religion, nationality, those were all looking backward at the type of persecution that had happened in the past. Particular social group can exist so we don't just fight the last war, so to speak. But the first adjudicatory body really in the world to seriously tangle with this question of what is a particular social group was the United States' Board of Immigration Appeals. And it decided it in a 1985 decision called Matter of Acosta. So the board looked to the international sources to some degree to try to figure out what the term meant. They couldn't do it. They looked at the congressional language that went along with the drafting of the Refugee Act. They found that was problematic. So they employed something that's called the exudum generis, and I'm butchering the Latin because that is not something I absorbed here, although I learned a lot. Was not Latin pronunciation. My apologies, Professor Miley. But in order to disambiguate this term, they looked to all the other grounds, race, religion, nationality, and they said, what do these have in common? And the board noted that each of those elements was something that's fundamental to the applicant's identity. It's something they cannot or should not have to change: your race, your religion, your political views. And so, noting that is the criteria that united all those different protected grounds that I mentioned, they interpreted particular social group to mean a group of people who share, right, any characteristic that they cannot or should not change. Importantly here, the possession of that characteristic doesn't make you a refugee, right? It doesn't qualify for asylum. It's whether you have a well-founded fear of persecution on account of, because of having that characteristic. And I'll just note, as foreshadowing for what comes later, sex and kinship ties are not central to the case, but noted in dicta by the board at Matter of Acosta as quintessential examples of particular social groups. So that is the law for a long time, and it actually becomes the internationally accepted standard. You can find decisions coming out of England, New Zealand, and even in the UNHCR materials talking about particular social group. They all cite Matter of Acosta. It's the touchstone for how that term is interpreted worldwide. But the Board of Immigration Appeals gets concerned about it. They feel like it's too broad, it's opening up the door to large groups of people who might seek protection. So they, starting around 2006 through a series of decisions, add additional hurdles for applicants to get to. And that, the most recent clear distillation of that is in a pair of cases called Matter of MEVG and WGR, and the appeal of WGR was my clinical project while I was here at the CNA. So they add two criteria that are in addition to the mutability criteria. You still have to have an immutable characteristic to be a social group, but in addition, the social group has to be discrete within the society in question, clear boundaries on who qualifies and who doesn't, and it needs to be perceived as a group by the society in question. So if you're asking yourself, what does that mean, or how does someone go about proving that, I don't blame you. Everyone's been struggling with it ever since. These new criteria are inherently problematic, and I'll turn to particularity first. One of the quintessential examples of a particular social group, and indeed a group that was recognized as a social group under the previous Acosta standard, is sexuality, right? In its jurisprudence, the board has said social groups may lack particularity where members can vary as to a variety of ages and genders. But of course, gay people can have any age, right? They can have any gender. Let's broaden the conversation a little bit to look at the other protected grounds, since that fundamental inquiry set out in Acosta is social group, substantively similar to race, religion, nationality? Well, reasonable people are going to disagree and have disagreed over whether or not someone is Jewish. Do they have to have matrilineal descent? Do they have to go to synagogue? Right? Where are we going to draw the line? And the reality is you can't. There's never a perfectly discrete social group. It's impossible to satisfy that. But what this has invited adjudicators to do is speculate as to some possible difference, but some possible ambiguity at the margin of the group, and then deny the claim. In addition to that, there's the social distinction criteria. What is the society's view of this group, qua however you formulated it? And that raises a whole other set of problems, one of which is that we don't know, you need to essentially have to bring in a country conditions expert who knows the breadth of the society of wherever your applicant is from to talk about that. And the other problem is social distinction as it relates to particularity. So because people were struggling with this issue of having a group that's broad, they started to add lots of modifiers to try to boil it down and make it really discrete. So you might have something like young women between the ages of 13 and 21 who are perceived as being vulnerable to harm by human traffickers. But the problem with that is that undermines the social distinction. So nonetheless, during this period, we had two Board of Immigration Appeals decisions recognizing social groups that met the standard. That was a matter of ARCG, litigated by our keynote speaker and her group at the Center for Gender and Refugee Studies. That was married women in Guatemala who are unable to relieve their relationships, and matter of LEA, immediate relatives of a certain family member. So guess what happens next? Those decisions go away. And the first, and so the Attorney General, Jeff Sessions, did exercised a power that's unique to immigration law of certifying a question to himself. In this context, the Attorney General, who may not have any specific immigration experience, is allowed under the regulations to pick out a decision from the immigration court system and redecide it. And that's exactly what happened here. But the decision was very messy. The particular social group in question was Salvadoran women in relationships that are unable to leave. Right? And the Attorney General said, nope, it doesn't count. But the question was why. If you look at the first quotation on the board, or that I've set out in the decision, you'll note that it's not actually any different than the WGR formulation. Is the group particular, socially distinct, and immutable? The Attorney General then went on to say, victims of private violence, and there he means victims of domestic violence and her fleeing gangs, will only meet these requirements in exceptional circumstances. And the question is why? Because the identity of the persecutor is not relevant to that tripartite test that's in the first set. It has nothing to do with particularity, immutability, social distinction. And there's also a much more narrow holding in AB, turning on the procedure of that case, whether the Department of Homeland Security was correct to stipulate that the record in that particular applicant's case, because this inquiry is a case-by-case analysis, met those three tests. And the Attorney General concluded it did not. So we're left with this very complicated decision that was very uninstructive to both advocates and decision makers as to what AB meant. And so you kind of had two schools of thought emerge. One, AB represents a categorical ban. We can't do asylum for people fleeing domestic violence or gang violence anymore. And one opinion that AB is actually really narrow. Everything in it is speculation besides the part where the Attorney General is talking about they failed to satisfy the burden in this case on this record. And that's actually the position the Department of Justice took in an appeal in the Eighth Circuit. So if you are a practitioner in the Eighth Circuit, you can find evidence of the Department of Justice taking this really narrow view. Within the Harvard Clinic, we've been continuing to fight domestic violence and gang violence cases after matter of AB. We usually articulate the social group as Guatemalan women, if it's Salvadoran women, etc. And we've had a lot of success showing that those groups are cognizable social groups. I've been collecting decisions from immigration judges across the country that have been granting relief on that basis. They are available, and if you are a practitioner in this area, you can be seeking them out and continuing to fight it and push back against immigration judges who make per se rulings. On the other hand, I was talking with Jody before the presentation today, and she pointed out that judges in her area have been denying these claims. And I want to make sure I touch briefly on matter of LEA, which is a more recent variation on the same thing. So matter of LEA was previously a precedent saying that immediate relatives of someone could be a cognizable particular social group. The Attorney General didn't like that decision, picked it out. This is Attorney General Bill Barr, and re-decided it. He said that families are unlikely to qualify as socially distinct. Again, we have the same kind of speculative statement as matter of AB, and the question is why. The Attorney General offered a little bit more clarification here and said that it's not sufficient to show that your family, your nuclear family membership has great significance in the society question, because then virtually everyone would be a member of a cognizable particular social group. We should look back at the Refugee Convention. The other grounds are race, religion, nationality. Pretty much everybody's got a race. Everyone's got a religion or a lack of religion, which can be a basis, or a nationality, just about. The operative question isn't whether you're a member of a particular social group, but whether you've been persecuted or will be persecuted on account of that basis. And so I'll be happy to talk about strategies for coping with these decisions after.
Great. Thanks so much. I am so honored to be here on this brilliant panel and to be speaking with so many of my mentors who are in the audience. I really appreciated Linus's comments earlier today about how it's a both and, how we really need, there's so much need for representation on the border, and there's a real need for representation here. I recently had the privilege to take a team of volunteers to Dili and was permanently heartbroken by seeing kids in jail with their parents, seeing moms just wanting to get treatment for their kids and not being able to, but also recently had the privilege to go do legal screenings in South Dakota in a series of small towns where we thought we'd be there for a few hours, and we rolled into small towns where it didn't seem like there was a whole lot of people around, but then hundreds of people came to our screenings. We were there until midnight, and we only stopped because we had to get up the next morning and go to another town. So there are so many people. Many of them handed us hearing notices for court hearings, were indigenous language speakers, Spanish speakers, and weren't often literate in those languages, much less in English, so they weren't able to call the numbers of legal services providers handed out by the court in English only. So there is a real need for representation here, and I feel really privileged to be meeting that need through my work at the Advocates. So I'm Allison Griffith. I'm an attorney at the Advocates for Human Rights, and we represent asylum seekers in Minnesota and in North Dakota and South Dakota. And we would love to work with any volunteers who are interested in working with us. So I want to start by saying that I'm going to talk a little bit about the attacks on the courts that we have seen in the last few years. But I want to start by saying that I have the utmost respect for immigration judges. They have incredibly difficult jobs. Immigration judges have been likened to be deciding death penalty cases in a traffic court setting. That's what the chief immigration judge has said about their cases. And they have been found to have as high levels of PTSD as emergency room doctors. So they really have an incredibly difficult set of cases to decide, and more and more challenges as as we've seen in the last few years. So this is coming from a position of utmost respect and wanting to see our judges have the tools they need to provide fair process to the people before them. So I'm just going to talk about a few of the highlights on the overall attacks on immigration judge independence, which have created such inconsistency between the stated goals of the courts and the realities that we're seeing today. A few of those tools are a few of those challenges are elimination of the tools for procedural fairness that the judges use to manage their dockets and ensure that they're focusing their attention where they need to. The case completion quotas, including regarding BIA remand, the attempt to restrict access to fair appellate agency decisions, and attempts to restrict the case law, which my colleague has talked about, available to judges to make fair decisions, granting protection to those who deserve it, and referring immigration judge cases to political leadership if they're not decided within arbitrary case completion goals. So just reminding us of the mission of the immigration courts, the stated mission, and this is by our current leadership, is to adjudicate immigration cases by fairly, expeditiously, and uniformly interpreting and administrating the nation's immigration laws. And so that fair and uniform aspect has particularly come under attack. We've noticed that there are extreme differences in adjudication depending on the judge, and the fairness part of that adjudication has faced many recent challenges. Justice Roberts has also said that the immigration courts are supposed to do equal rights to those appearing before the court. And in particular, as relates to asylum seekers, the courts also are tasked with upholding our nation's obligations under both international and U.S. law to provide protection to those fleeing persecution. But that mission is inherently threatened where the independence of the judiciary is impossible because it is part of the executive branch. And it's particularly challenging in the context of our current executive branch, where the leadership is highly sensitive to the goal of protecting borders and may therefore have an interest in denying asylum in favor of meeting that goal. Recently, former AG Sessions proposed a different mission to immigration judges at the Immigration Courts Legal Training Program. He suggested that the goal should be to have zero illegal immigration in the country and reminded the immigration judges in attendance that they are required to conduct proceedings subject to the supervision and performing the duties that the AG prescribes. So immigration judges share with us that they're receiving constant reminders that they serve at the pleasure of the AG. And in that context, it's very difficult to feel that they have the freedom to make decisions that they should be able to that are comporting with due process. The president of the Immigration Judge Union has said that there are repeated conflicts of interest of late between protecting the integrity of the court and the independence of immigration judges from infringement by the perspectives and positions of a law enforcement agency within which the immigration court is housed. So I'm going to talk about just a few of the tools that immigration courts have created over the years to seek to ensure procedural fairness to the people before them. There's been a continuous chipping away in decision after decision by the AG of these tools, making it extremely difficult for judges to focus on their limited resources on managing their dockets and getting through their caseload. So courts have long used administrative closure to pause proceedings when a different federal agency, for example, U.S. Citizenship and Immigration Services, has jurisdiction over the claim of someone who is before the court. However, in the Castro-Tum decision, the Attorney General gave ICE attorneys the unilateral power to keep a case from being administratively closed and said that cases can be recalendared by either party. The result has been random recalendering of administratively closed cases. Our office has seen several kids who are eligible to seek asylum before the asylum office and have been waiting for years to have interviews be recalendared, so they have to keep coming back to the court every few months and say, yes, we're still waiting, and the court has to say, okay, you can keep waiting. And we also have seen people who are eligible for T visas be recalendared, and the DHS attorneys say, we'll agree to continuing the case, but not to keeping it admin closed. So continuing to have the court having to be monitoring all of these cases where the court really has no role in adjudicating. We're also seeing this in the context of USCIS processing times increasing by 46% in the last 2 years and 91% since 2014. So this is a situation where we're seeing cases get put back on a deportation calendar, but waiting for much greater times for USCIS to process the cases. We also saw a decision imposing a higher standard of good cause for continuances, so suggesting that the court can't even continue cases unless certain additional standards for good cause are met beyond what they were having to consider previously. And so this is clearly an effort to speed deportations while also slowing relief to those before the court. Another recent tool that's been taken away is termination of proceedings. In SOG and FBD, the AG said that immigration judges have no inherent authority to terminate or dismiss removal proceedings, and can only do so in circumstances expressly identified in the regs, in the regulations. So there's numerous cases where termination would allow USCIS to process adjustment applications or otherwise would permit an efficient use of agency resources and not have people coming back to the court, which is particularly important in our jurisdiction where people are often live many hours away from the court, have to make dangerous drives on freezing cold, snowy days to get to the court, many of my clients have to pay hundreds of dollars to get transportation because they don't have their own driver's license, miss work, their kids miss school. So there's a lot of concern with these policies. So one thing that we're seeing is kids eligible for special immigrant juvenile status, because they were abandoned, abused, or neglected by one or both of their parents, who used to be able to apply for adjustment before U.S. Citizenship and Immigration Services, will now have to seek adjustment in adversarial proceedings before the court once they finally get a decision on their cases. Another recent concern was the matter of MS case, which suggested that an alien who was transferred from expedited removal proceedings to full removal proceedings after establishing credible fear in a credible fear interview while detained would be ineligible for release on bond. And this would have the application of this decision is luckily currently enjoined by a lawsuit, the Padilla suit. But if it were to be implemented, would contemplate a truly breathtaking increase in mass incarceration of immigrants, where there are more humane and effective alternatives to detention available. I think it's like 99.9% of represented non-detained immigrants show up for their hearings. That's just an estimate, but the AIC has that data. So we've already seen a massive increase in incarceration under our current leadership, but that decision would have massively increased detention in areas where there's less access to counsel and a lot of concern regarding ability of individuals to access evidence, be with family, support their children. So another concern is that we're seeing the elimination of immigration judge and ICE attorney contact with stakeholders. So the nonprofits locally who provide screenings to unrepresented families and kids at the court used to meet regularly with the court quarterly to discuss concerns for children and families, for detained individuals' access to the court, and how courts could promote pro bono representation. This was an incredible opportunity for the court and our offices to think creatively together about how we could solve problems that impacted respondents before the court. So we came up with the winter hotline as a result of that meeting, where people could call in at 5 a.m. and find out if court was happening. And at least if they were already on the road at that point, they could turn around instead of making the journey the rest of the way. The children's play area came out of those meetings. Some of the advisals to unrepresented respondents that were made about the availability of counsel, that were just a few results. It also permitted the court to highlight particularly vulnerable individuals to the nonprofits representing children and families. One of my current clients is a result of an immigration judge saying, this person seems like they are really struggling with this. Can someone go talk to them and make sure that they get representation? And immigration judges, asylum officers, and ICE attorneys are now unable to speak to students or to the public, even in their personal capacity. I remember we invited ICE attorneys when I was a law student at St. Thomas School of Law to come speak to our Immigration Law Society. And it was really wonderful to hear from them in their personal capacities about what they find challenging, what they're proud of, and also to hear them say they feel their job is to enforce the law, not to deport people in every case. I think it was good for them and good for us. And I know, Steve, that you shared similar, that the judges were able to speak to your students before, and that's been going away. So as we're seeing those tools leave, we're also seeing the judges be under extreme pressures to complete cases. So they're being required to complete 700 cases per year. 95% must be completed at the first scheduled individual hearing. And these are extremely record-intensive cases. After the AB decision that my colleague was mentioning, ICE issued a memo to trial attorneys nationally saying to expect voluminous records from respondents following the decision, because that was what they acknowledged, that's what was going to be necessary for respondents' attorneys to meet their burden in representing their clients. And it's also concerning to see that the judges are being required to have no more than 15% of their cases reversed, particularly in light of the highly politicized recent court hires at the BIA level, which I'll mention in a moment. Important to note that no other agency courts are subject to similar quotas. Other agencies do have case completion goals, but those goals are used to determine resource allocation, whereas the immigration court's case completion quotas are tied to immigration judge performance evaluation. And I've heard from colleagues that the immigration judges have these pictures in front of them when they log into their computers, that it has a green, yellow, and red area to show them where they are in terms of their case completion goals. The former immigration judges, of course, have said that their colleagues find this demeaning. So as a result, you can see that these case completion goals are not just meant for efficiency. Former immigration judge Jeff Chase, when asked by a reporter what to make of the case completion goals, said to take a look at the court with the highest denial rate in the country, which is Atlanta. Dividing the total number of case completions by the number of judges in that court, those judges averaged over 1,500 completions for the year, or more than double what was required to meet the quota. And then they did the same for one of the more liberal courts in the country, the New York City court, and found the judges there averaged just 566 completions a year. So it's a lot harder to write a decision, I presume, not having written one myself, but where you have to think through every aspect of the burden of proof and write why the individual has met those burdens rather than denying the cases. So this is the quotas are not designed, we can say, to have a neutral impact. We are seeing an increase in denials, but I think the reason we're not seeing more denials is because there's a lot of brave judges who are standing up for justice, even under these intense pressures. Judges are having to repeatedly choose between the requirements of due process and their own job security. And this is a situation where they should be having the independence to take the time they need, including a second individual hearing to receive additional testimony where they find it appropriate. So I have a lot more to say, but not much more time. So I'm just going to wrap things up quickly. So there's also been a history of politicized hiring in the immigration courts since the 1980s. There's been politicized hiring of immigration judges under the Bush administration, but now we're seeing under Trump that there were Obama appointees that were delayed and blocked. I want to highlight quickly that the most disturbing hiring we're seeing are the 6 judges recently appointed to the board who were, they have some of the highest asylum denial rates in the countries and the highest number of decisions that were sent back by the BIA for reconsideration. There's lots of anecdotes that I could share with you that are really concerning. One of the judges was the one who had denied asylum to Miss AB, although she had survived more than a decade of severe domestic violence, and he will now be deciding the appeals coming from the immigration courts. My colleague has talked about AB, basically some of the protections for asylum seekers that we've relied on for decades that are particularly important to Central American asylum seekers are being curtailed. There's cases that have been made it more difficult for us to fight for survivors of persecution who were forced to provide basic assistance under duress. So basically, I'm going to just jump to the solutions because I want to end on a positive note. We've given you a lot of things to be really sad about, and I had some more stories I was going to tell you about individual cases that have made me really sad. But there are things that we can do to respond. So we need to advocate for immigration judges to have an independent court that is not part of the executive branch. Immigration judges themselves have been advocating this since the 1990s. And we will really start to see more universal, truly fair, objective adjudication once the courts are taken out of the political branch. But right now, we really need volunteer attorneys, volunteer interpreters, court observers. We are winning. Our volunteer attorneys have a more than 70% success rate for cases they take on. These are challenging cases. Steve and his clinic recently fought and won a challenging case before the court. And these are longer fights. So we really need to see people who want to accompany asylum seekers to commit to the long fight if they want to truly have an impact. I will say that although there hasn't been a massive increase in, as my colleagues were saying, necessarily in immigration over the long haul, we are seeing this year, more than even the first year of the surge, more families and unaccompanied minors fleeing to the United States than ever before, and fleeing to Minnesota specifically. So we really do need your help for these individuals to get representation. And the single biggest factor in whether these individuals succeed in their cases is whether they have attorneys. So the 27,992 unrepresented individuals before our local immigration court really need your help. So please prepare for a marathon. We have to be fighting every due process violation, making our records and preparing our clients for a long fight. And we have to be a little braver, a little smarter, fight a little harder, and keep fighting for our judges to have the tools so that they can do the same.
Great. Thank you. All right, thanks very much to the panelists. I have just a couple of quick comments before we open up to questions. Jody mentioned the fabricated crisis or invasion at the border, and what's interesting is a very little discussed U.S. policy that has or is a reason why there is really no invasion at the border, but also why there is a perceived invasion. And that is a policy that actually started in the second Bush administration, where the U.S. has been providing millions of dollars to the Mexican government to fortify the other southern border, the border between Mexico and Guatemala, and also to apprehend, detain, and deport Central Americans within Mexico. What that has resulted in is a flip in a trend where up until a few years ago, the U.S. had always detained and deported more Central Americans than did Mexico. That flipped a few years ago. Now Mexico apprehends, detains, and deports more Central Americans than does the United States. So fewer people are making it to the border because Mexico is doing the police work for the United States. But the reason why that policy has resulted in or part of the reason it's resulted in the impression of an invasion goes to those pictures that Jody was showing about the caravan, because what's happened as a result of that increased enforcement by the Mexican government is that a lot of the migration routes that folks traditionally took from Central America have been blocked. And so for a while, what a lot of the migrants were doing from Central America, they were taking different routes. Those routes, though, were quite dangerous and resulted in sexual assault and other forms of assault. So over time, strength in numbers, as Jody said, people started to coalesce into these caravans. And as a matter of security, then they came to the border en masse. Of course, pictures of that have played to the fears of the American public and have provided grist for the mill for politicians who want to limit the right to asylum. Not to end on that grim note, I will say that maybe, I don't know if it's a form for optimism or some sense of perspective, but when Allison was talking about quotas and such, at least we haven't gotten to the point that they have in the UK, or at least they had previously, which was, this was under, when Theresa May was the Home Secretary. She, or the department, instituted a policy whereby any judges who met the denial rate for asylum claims was given a £50 gift card to a local department store. So at least we haven't gotten to that point yet. All right. So now the floor is open for questions.
Okay. I'm interested in hearing more about how the guidelines have changed as far as demonstrating credible or reasonable fear in asylum cases. Could you maybe elaborate on that a little more?
Well, what I can tell you, at least along the southern border, is that there is no longer a credible fear process for those individuals in MPP. There is an interview that can take place called a non-refoulement interview that has sort of a made-up standard. It's not really a credible fear standard or a reasonable fear standard. It's something else. But what I can also talk about is the change in the credible fear standard after Matter of AB. During the month that Matter of AB came out, that was a time period where we were dealing with family separation, and there were lots of parents that were separated from their children. They were in detention. And we saw the credible fear passage rate go from roughly around 70% to dropping to around 4% in 1 week, right when Matter of AB came out. And that was after there was a memo that was issued to the asylum officers to instruct them in terms of the application of Matter of AB to the credible fear interview. So I think that, certainly what asylum officers are being told changes, and that change can be implemented pretty quickly, which was particularly relevant right after Matter of AB was decided.
And I'd add to that with specific regard to particular social group cognizability, that memo implementing AB in the credible fear context was actually enjoined by the District of Columbia in a case called Grace v. Whitaker. So when you look it up online now, there's actually interesting parts where there's just strike through parts of the memo and it says, don't apply this, but if it gets overturned, we're coming back. What Grace v. Whitaker says is that the credible fear officers are supposed to apply the law of the most favorable circuit. That's really important with respect to particular social groups because the Seventh Circuit has refused to defer under Chevron to the particularity and social distinction additions to Acosta. So if you're dealing with a credible fear case, you should be fighting that you only need to meet immutability to have a cognizable social group, at least with respect to credible fear.
The other development in this area is that it's another new policy of the administration that's being challenged. And what it says is it requires asylum officers to rely on State Department reports in evaluating credible fear. In the past, that had been optional, and also that the government had listed a whole host of possible sources of information as to country conditions in the country from which people are fleeing. Under the current proposal, the only specifically mentioned source, and the one that they're required to rely on, is the State Department report, which they deem to be objective. And anybody who knows about the history of the State Department report for many, many years, not just recently, is that it is prone to political influence, non-objectivity, and also is not comprehensive. So the fact that asylum officers who are already under tremendous pressure to decide cases quickly are now being mandated to rely on a politically charged and limited document is going to have serious consequences for the process.
And also this new safe third country policy, right? Which has been implemented while the case is being decided, will mean that anyone who has traveled through Guatemala, Honduras, El Salvador, which is not just folks fleeing from Central America. We see a lot of people who are fleeing from violence in Africa or other areas of the world, traveling to Central America to present at the U.S. border and seek asylum as they're legally allowed to do. So anyone who has traveled through those countries is being required to show that they were denied asylum by one of the countries that they traveled through, where we've seen that there is very limited, if they entered the country after a certain date in July 2019, we see that there's very limited access to the asylum system in many of the countries that folks are traveling through. So that's very concerning change in the CFI process, and people are having to prepare to make torture claims where they could have previously passed easily on social group.
So I've got a question. So we've been seeing quite an uptick in the number of gentlemen in the Freeborn County Jail that have just crossed the border, like over the last month or two or three, from Mexico, Honduras, and El Salvador. And the thing that just doesn't seem to make sense is that a lot of them, the great majority, look like they're seeking asylum, and yet when they go to court and they ask if we can be there in court, they're basically explaining a situation with gang violence. And in every one of those situations, they've lost the case because the judge says gang violence doesn't come under any of those categories to qualify for asylum. So why are we transferring people from the border, flying them or busing them in Minnesota, having them be detained for 1, 2, 3 months and go to court and end up with a master calendar hearing and then a final hearing if it's going to be an asylum situation is going to be rejected? I don't quite understand that process.
So it's not necessarily going to be rejected, which goes to kind of the heart at what's at the AB case. People qualify for asylum when they have a well-founded fear of persecution, either from the state or from a non-state actor that the government is unwilling or unable to control. The Eighth Circuit has a slightly different standard, which is problematic for other reasons. So a gang, for example, can persecute someone, and that falls within the rubric of asylum. The question is that gang persecuting that individual because they have one of those protected grounds? And so, the because is sort of misleading. The standard under the law that was passed by Congress in 2005 in the Real ID Act is the protected characteristic one central reason, right? So I'll give you an example. I had a client who was very religious and was, very anti-violence as part of her religious beliefs. And she was organizing church activities in a Central American country to get kids away from MS-13 and M-18, as it were. That was part of her religious creed and practice, right? Because she was doing that, she came under threat from one of those organizations. And we were able to show that she had a well-founded fear of persecution on account of her religious creed. That's not the only example, right? These gangs are also very political actors in Central American countries. There's a lot of expert evidence out there showing that, they really are in control of a lot of communities, and therefore, applying who's got a monopoly on the use of violence in that area, opposition to these gangs is really a political act. So it's not a simple question of gang violence or domestic violence or not. You have to work through the steps that are set out in the Refugee Convention.
Yeah, and just to share a few local examples, it's very explicit, as my colleague said, in the law that even if there's generalized violence in the country, then if you are more at risk, you can receive protection if you're more at risk because of a protected ground. So we've seen former police officers who were targeted by gangs, testifying witnesses against gang violence, family members, so children of officers who were targeted by gangs, and others who can show that a shared past experience with other similar individuals or some aspect of their identity that they can't change has led to the persecution they've faced, receiving protection from our court here in Minnesota. We have seen expanded representation of detainees. Make sure that you're communicating with the nonprofits if you're seeing folks in this situation to try to get them counsel. And the advocates recently put out an 8th Circuit practice advisory on AB claims specifically. We're looking to put out some more guidance on other local cases. There's gender-based violence by gangs, and then there's also other types of gang violence that individuals can receive protection from if they have a protected ground that they can successfully assert.
Hi there. This is a question about children being separated from their parents. Do we know, or could you give us an update on the numbers? How many are still separated, and what is the average length of the separation, and what can be done to hold folks accountable in these government agencies for traumatizing these children?
So I think what we know at this point is that there were somewhere around 5,400 children that were separated. Currently, there's about 1,500 children that are separated. In terms of the average length of the separation, that varies because during zero tolerance and the family separation crisis, the average length of separation was somewhere around 6 weeks. But I did work with children that were separated for as little as maybe 4 weeks, and then I just reunited my last child from family separation. In other words, was taken from his parent in June of 2018 last month. So that was a separation that was about 14 months long. The current sort of scheme of family separation, the separations tend to be somewhere around 3 or 4 months, and I don't know, Daisy might have some different statistics, or I'm not big on statistics because I deal with the individual cases, but.
No, that's about right. Yeah.
And the ACLU has recently initiated a civil damages lawsuit on behalf of the families separated as a result of that policy.
I will say we've seen a lot of separated kids in Minnesota where the parents got deported and the child was put in an ORR facility and eventually reunited with some other family member. And in those cases, the family separations have been often very long, many months, if not years. And We also see, as Kathy mentioned in an earlier panel, lots of kids separated by other policies, such as detention of their parents and deportation of their parents away from them.
Okay, we have to stop there because we want to have a break before the keynote address. So thanks very much to the panel.